and I have been practicing in Bombay High Court since last 15 years. And this channel is specifically created for the purpose of helping young law students who are curious to know about the case laws and the latest case traditions. Today we are going to discuss the very important topic of bona fide need of a landlord to get the possession back from the tenant. Dear friends, we have seen and observed that large number of litigations are pending in small cause courts in Maharashtra and many other states in this country when the landlord is striving hard to get back his possession from the tenant. Dear friends, either there is an agreement of leave in lease with the tenant, or there is no agreement or the oral arrangement made between the parties. The landlord is entitled to get back the possession. But in most of the cases we have seen that the tenant is reluctant to give the possession, and therefore the landlord is compelled to file a suit of eviction or suit for possession in the small cause court. The suit goes on for years, and then finally the landlord may get the possession if he succeeds in arguing the matter in accordance with the law. The settled position of law needs to be known to the lawyers on both the sides. On what account the landlord can get the possession? What are the ingredients which are required to be pleaded and argued before the court on behalf of the landlord? Now, what is the defense available to the tenant? All this will have to be discussed. And dear friends, we are going to discuss all these intricacies in today's video. Keep on watching Courtroom Battle. Dear friends, what are the circumstances in which the landlord can take the possession back from the tenant? Under section 16 of the Maharashtra Rent Control Act 1999, the landlord has a right to seek back the possession from the tenant. Now there are number of instances by which the landlord can rightfully approach the court and seek the possession. 16(1)(a) says that if the tenant has committed act contrary to section 108(o) of the Transfer of Property Act, then the landlord can seek the possession, which means that if the tenant has done some damage to the property, then the landlord has the right to seek back the possession. 16(b) says that if the tenant has made some construction without valid consent of the landlord or without any permission and made the permanent structure therein, then the tenant has violated section 16(b), and therefore landlord can take back the possession. If the tenant has caused nuisance or annoyance to the adjoining neighbors, then the landlord has a right to seek back the possession. The tenant cannot be a nuisance creating tenant, because of whose presence, if the neighborhood is going to be troubled, then section 16(c) gives right to the landlord to seek back the possession. 16(d) gives right to the landlord to seek back the possession in the event if the tenant has given a notice to quit and consequently the landlord in fact has contracted to sell the property to somebody else and the tenant retracts to vacate the premises. Then the landlord has a right to seek back the possession under 16(d). If the tenant has illegally sublet the premises without the permission of the landlord, then in that event, the landlord is entitled to seek back the possession under 16(e) of the MRC Act. Landlord can seek the possession back under 16(f) when the premises is handed over to the tenant for his personal use as a residence or quarters, when the tenant is in service of the landlord, and when the tenant retires or ceases to be in service of the landlord, landlord is entitled to get back the possession under section 16(f). Section 16(g) is most important section, dear friends, that for the purpose of bona fide use of the landlord or any other person, the landlord is entitled to seek back the possession from the tenant. Now dear friends, what is bona fide use is a big issue and it has been time and again interpreted by several court decisions. We will discuss those case laws later on. But large number of cases are in fact invoked under section 16G of the Maharashtra Rent Control Act 1999. When the landlord moves to the court to seek the possession back for his bona fide use or personal use. Under section 16H, the landlord can seek the possession back from the tenant in order to carry out the repair works of the premises which otherwise could not have been done without vacating the premises by the tenant. In order to carry out the repairs in the premises, landlord gives notice and he can seek the possession back from the tenant. 16I gives right to the landlord to seek the possession for the purpose of immediate demolition of the structure or the premises so as to construct the new building. If the landlord wishes to demolish the old building and he wants to construct the new, he can seek the possession under section 16I. Under 16J, landlord can seek possession in order to make some further construction on the terrace floors. If the landlord wishes to make further construction on his existing building and the tenant is residing on terrace, then that particular tenant can be evicted for the purpose of continuation of further more stories on the building. Under 16K, possession can be granted to the landlord in the event if the demolition is required to be done by the municipal commissioner or the municipal authorities. Under 16L, if the premises is an open space or in nature of the garden, then with the previous permission of the NMC authorities, in the event if the landlord wishes to make the new construction on the adjoining plot, then the possession can be sought. Under section 16M, the landlord can seek the possession back in the event if the tenant recovers more amount of rent from the subletted premises than the standard rate or the permitted increase. Under section 16N, landlord can seek the possession back in the event if the tenant fails to make good use of the premises for continuous 6 months prior to the date of filing of the suit. So dear friends, these are all exceptional events in which the landlord can seek back the possession from the tenant. But for the purpose of getting the possession, landlord has to make a suit in the small cause code under section 16. Now what is the bona fide use of the landlord will have to be defined and observed by the court. At the same time, there is a necessity of the landlord to pass the test of the bona fide use. The question of greater hardship. In the event, if the court comes to the conclusion and the landlord passes the test of the bona fide use, then the test of greater hardship will have to be passed by the landlord. Under section 16(2) of the Maharashtra Rent Control Act, it is mandatory for the court to see that who faces the more and greater hardship in the event of giving the possession to the landlord. If the landlord doesn't get the possession, whether the landlord faces the more greater hardship, or if the possession is handed over to the landlord, then whether the tenant faces greater hardship. This is to be decided by the Honorable Court while granting possession to the landlord. Now there are celebrated case laws on this aspect which will have to be seen. If you are a counsel for the landlord, dear friends, what are the important points which are required to be pleaded and argued on the part of the landlord? If the suit is filed under section 16(1)(g) of the Maharashtra Rent Control Act 1999 for the purpose of bona fide use of the landlord, then there is a need and requirement of the landlord to plead in his averments and argue that he seriously and bona fidely needs the premises for his personal use or for the purpose of any other person for which the premises is held. Landlord may seek possession for carrying out the business of his family member also, but the test is required to be passed by the landlord. Firstly, landlord has to come up and give details of all his properties. Secondly, the landlord has to come up and plead that in spite of having all these properties, he basically needs only these premises which is being held by the tenant. In a celebrated case, Vivek Paturkar versus Sulochana, the Honorable Bombay High Court has clearly defined the test of comparative hardship and the test of bona fide need. 2022 SCC Online, Bombay, page 441. Justice Vinay Joshi has categorically held that the landlord has to pass the test of the bona fide need and also pass the test of comparative hardship under section 16(2). Landlord must make a demand of possession elaborately and obviously for the purpose of bona fide use. The demand of the possession for the bona fide use should be reasonable. Landlord must come up with clean hands and declare all his properties available to him or which are also not available for the purpose of carrying out the bona fide use which he pleads in the courtroom to get the possession back. The landlord also has to plead and argue that in spite of availability or non-availability of other properties owned by him, he specifically requires the premises held by the tenant for a bona fide use or a particular purpose. The important part in this which is required to be considered, dear friends, that the landlord should say that for the purpose of having the bona fide use, this is the only property which suits his bona fide need and no other property suits this need, and therefore tenant has to vacate the property. It is the duty of the landlord to elaborately describe details of other properties and also elaborately argue, plead and describe the need for carrying out his business or his personal use in order to seek the property under 16G, that is bona fide use. The Honorable High Court says that the element of need must be genuine and must be in good faith. The need cannot be superficial or artificial. The bona fide need needs to be proved to be very genuine. A landlord cannot fancifully say that I need these premises for the purpose of carrying out the business for such and such reasons. If the landlord has got many other businesses or if the landlord has got many other properties to carry out his need of the business or need of the use, then the court may not come to the rescue of the landlord. And if the landlord passes this test of the bona fide need, then the court has to move forward and further conduct the test under section 16(2) of the greater hardship. Who will face the greater hardship is a big question, dear friends. In the event, if the possession is granted to the landlord, whether the tenant faces the greater hardship, or in the event, if the possession is refused to the landlord, whether landlord faces the greater hardship or not. This question also needs to be answered by the court. If these two tests are carried out by the court, then there is another test which is required to be seen, and in spite of having not pleaded, the court has to conduct this test suo motu summarily, that whether the court can grant certain portion of the premises in possession of the tenant to the landlord to carry out his bona fide use. Say for example, a landlord wishes to start a restaurant in his premises, and if the tenant has got more space than the need of the tenant, then certain space can be granted to the landlord in order to start his business. The Honorable Supreme Court has once held that it would be right approach to have the proposition live and let live and have humanistic approach. 1977, 3 SCC 517. Dear friends, Honorable Supreme Court in Badri Narayan versus Govindram has discussed the comparative hardship. 2003, 2 SCC 320. The Supreme Court says that the burden of proving greater hardship is on the tenant, but burden of proving need for eviction is on the landlord. Landlord has to come forward and prove that there is a reasonable need for his personal use. Similarly, tenant has to prove that greater hardship will cause to him in the event if the eviction is ordered. In spite of finding that the landlord has passed the test of reasonable need, the court may refuse the eviction or the possession, and court may direct the tenant to continue. In the event if the test of the greater hardship is passed by the tenant, if the court feels that in case of eviction the tenant will lose livelihood and greater hardship will cause to the tenant, then in spite of passing the test of the bona fide need, the court may not grant possession in favor of the landlord and tenant may continue. In a landmark case of Bismillah B versus Muhammad Anwar 2010 2 MHLJ 829, the court says that there is a need of the test to be carried out by every court so as to identify the bona fide need. Section 16(1)(g) of bona fide need and 16(2) of the greater hardship will have to be construed harmoniously and will have to be interpreted together. It casts statutory duty on the court to make an inquiry in order to conduct the test and in order to give its finding for the purpose of granting the possession on the bona fide need. The court is required to make further inquiry for the purpose of conducting another test of greater hardship. Dear friends, it's a long and big battle between the landlord and the tenant. The landlord has to be very careful while framing the issues or while pleading before the court. Therefore, if you are a counsel of the landlord, I advise you to go with these case laws. Make correct pleadings before the court. Please make sure that the bona fide need can be proved in your favor if you are a landlord. Secondly, don't forget, come up clean with the hands and give all the details of the properties available of the landlord. Thirdly, make sure that you create and bring the evidence which is required to be brought before the court in order to prove that landlord is really in need of the possession and landlord has to pass the test of the bona fide need. Dear friends, seeking possession is not that easy. We have seen the tenants are fighting tooth and nail till Supreme Court. But I believe that this kind of information will benefit large number of tenants and landlords in this country. Please continue watching Courtroom Battles. Thank you so much. If you have not subscribed to our channel, I request you to please subscribe to our channel, and if you have liked the video, please like it and share it among your friends.